in 2011, the Administrative Conference of the United States came up with a recommendation on incorporation by reference that addressed these issues of accessibility of private standards. And the solution that they urged, which was one that I had urged in my report to the Administrative Conference, was a collaborative solution that said to agencies, because the Administrative Conference only gives advice to agencies, it doesn't give advice to the private sector. It said to agencies, if you are going to be incorporating by reference some kind of material that is copyrighted, including a standard, you need to be aware of the consequent restrictions on the accessibility of that material. And you need to take some kind of action to try to make sure that it is as accessible as it needs to be for your regulatory industry, your regulated industry, and also for the members of the public who might be interested in your regulations and want to participate in your process and know what the law requires. And so it says to agencies, if you're incorporating by reference something that's copyrighted, you should work with the standards developer and ask them to put a copy of the standard, perhaps protected by read-only protections, online, both during the rulemaking process and then also once you've finalized that regulation and have included the standard in your final regulations. And one of the good things about this is that it allows the standards developer to retain copyright, to protect its revenue stream, while still providing a copy on the internet that members of the public and other interested parties can look at and be able to read and know what the law says. It turns out that bootleg copies of standards are actually a thing. And for example, the National Fire Protection Association for over 15 years has been providing free online access to all of its codes and standards, and it uses a program that provides read-only protection. But their ability to retain their copyright has made it possible for them to ensure that people aren't selling bootleg copies of their standards, which is not important just because, you know, they need the revenue. It's important from a public safety perspective as well. You want to ensure that copies of the standards that people are using are full, complete, and accurate copies of the standards. And if not, you can have real health and safety consequences if there's some error in the printing or something that's missing, or it's an old version of the standard that's being peddled as if it's a new version of the standard. You want the standards development organization to have the ability and the incentive to ensure that the copies that are circulating are copies that actually should be used. And NFPA, for over a decade before the Administrative Conference issued its recommendation, was able to successfully use read-only technology to strike this balance between providing access to its standards and still retaining control over the publication and still protecting its revenue model and its independence as a standards development organization. And that was part of the inspiration to me in coming up with this recommendation that agencies should push standards developers to try to follow NFPA's lead and use read-only access as a way to improve the accessibility of the standards without undermining the standards development system or the revenue that's needed to create standards. And it's actually been much more successful than I would have thought, actually, and I thought it could succeed. Within the few years after the Administrative Conference issued its recommendation, ASTM International, which again is the largest standards developer in the U.S., created an online portal of all its incorporated by reference standards, where it uses read-only technology to provide access to the standards without undermining its revenue model. ANSI, the American National Standards Institute, created an online standards portal that allows smaller standards developers that don't have the funds to invest in the IT infrastructure that's necessary for that read-only technology to be able to provide that kind of access to their incorporated standards, and they launched that, I believe, in 2012 or 2013. And so in a case study of pipeline safety regulations that I did in, I believe it was 2012, I actually found that 66% of the standards incorporated by reference into federal pipeline regulations were already freely available online at the time that I did my study, and that was a year or two after the Administrative Conference issued its recommendation. So collaboration can work. It doesn't have that satisfying we've solved the problem all in one fell swoop feel to it, like sort of bald free access requirement might. But it has the advantage of, despite its incremental nature, really being, I think, a successful path forward to preserving the ability of agencies to protect the public and fulfill their statutory missions to the full extent, to allow them to comply with federal standards policy, which again is embodied in statute. It's not merely a suggestion, it's a statutory requirement, to protect the copyright of standards developers, and at the end of the day, to preserve the ability of private organizations to continue to create the standards that for over a century have really allowed our economy to work and have protected health and safety even beyond the reach of federal regulatory regimes.